Houston defense lawyer Mario Santos here. I want to make sure that I walk you through what exactly, at least here in our office, how we break down a criminal case. There's quite a bit of confusion as to what to expect. I just got arrested. I'm scared as to what can happen. We want to make sure that we educate you. That's more important to us, okay? Educate you on what the process looks like, on what we can do, on what kind of evidence is required, what are the elements of law, depending on the allegation that you got charged with. But let me break down in simplified form what really are the phases of a criminal case and how we handle each of these phases. The first one is what I call the pre-charge phase. This is before there's ever any charge that gets filed against you. In that phase, this is typically consisting of somebody calling 911, making an official report, or in some cases, they receive certain information. And when I say they, I mean the DA's office or an investigator, a detective. They receive certain information and they're conducting a criminal investigation on the matter. They haven't charged anyone just yet, but they have certain information that they're working on to then gather and ultimately then present to the DA's office. This phase is extremely important for you to make sure that you understand that you have the legal right to remain silent, okay? Don't feel obligated that, hey, look, somebody's calling me, asking me to, make sure that I give a certain statement. Why don't you come on down here to my office and provide as to what exactly it is that happened? This is just you giving information to the state that will then be used against you in the court of law. Okay, make sure you avoid putting yourself in a situation where in your efforts to hopefully clarify some misunderstanding that you give inconsistent statements that will then be utilized against you. In that phase, if you feel that there's a need to clarify some misunderstanding, do so via a legal representative, okay? Do so via someone who's a professional in the field that can then provide you some more guidance, some more instruction on how to provide an accurate and detailed statement. But my recommendation has always been remain silent. If they're conducting an investigation, that means that at this point, they don't have sufficient information to believe that you committed the offense. This is what the pre-charge representation entails. Now, I'm giving you this information with the understanding that each and every criminal case is completely individualized. Okay, I don't want you to think that because I'm saying something here on this video, that is specifically how it's gonna work on your case. Each case is completely different. There's different circumstances, different people involved. So we wanna make sure that we look at every single case with that perspective of what's going on specifically with this case itself. Can we find certain ways to hopefully avoid the charge? Make sure you reach out to a professional, okay? That's what you call the pre-charge representation phase. Now let's move on to this second phase. This is now the formal charge. An investigator or detective gathered up sufficient information that then presented that information directly to the DA's office. The DA's office, after analyzing properly that evidence, made the decision to say, we have sufficient information to believe that this person committed this offense. And they then accept or decline charges. Typically, if the case is that they filed something against you, that means that they accepted the charge, okay? So now you have to consider, is there an active warrant against you? If that's the case, you have to look at what are some of the options to address the warrant. If we can find a way here at the office to avoid an arrest where we coordinate with the presiding judge on your case to set a bond rather than actually have you taken into custody, that's gonna be our effort. But at that point, if we can avoid the arrest, if we can appear in court here with you, where it's called an arraignment setting, in that setting, what happens is that the judge will explain to you, look, Mr. Santos, this is exactly what you've been charged. This is what you are now facing in terms of punishment range, should the case be that the DA's office can prove this case beyond a reasonable doubt in a court of law. Just because you got charged, keep this in mind, folks, just because you got charged does not mean that you're guilty, okay? You have the legal right to be presumed innocent, and our job as defense lawyers is to make sure that we get in there, start looking at what exactly they have in terms of evidence. Can they really prove this case beyond a reasonable doubt in the court of law? But we want to make sure that we demand that your most important right, which is a right to be presumed innocent, gets respected in and outside of the courtroom. And so we are going to look at, in that arraignment setting, judge, our client is not guilty. We want to make sure that we formally demand from the DA's office every single bit of evidence that they have so that we can then properly analyze what is exactly this extent of evidence that they're going to utilize against you in their efforts to prosecute you and prove the case. Now, this is the formal charge phase, okay? The third phase is what I call the discovery phase. This is where we want to make sure that we gather up any offense reports that were handled by the either investigator, the detective, the lead officer on the case. If there was any photos that were taken, we want to make sure that we gather up those photos. If they obtained any audio recordings from any witnesses or potentially yourself, that's what we want to make sure that we also gather. Now, in today's day and age, these officers, they carry body cameras in their uniform. And so any statements that are collected, whether it be, at the initial scene or after the scene, they are going to be on that body camera video. Okay, those statements. And so any questions that they may have asked, any responses that you may have provided, or any other statements that were made by other witnesses, that's going to be on that body camera video that we also want to make sure that we get our hands on. Now, if somebody called 911, there's going to be an audio recording of that phone call that we can then listen into closely and figure out, okay, who's the person that called, at what time did they call, what exactly did they state that they observed or that they heard, for example. Is it consistent once the officers got to the scene and started gathering up information directly from that person or somebody else? Or is there inconsistent statements? These are things that we then utilize in your advantage, in your favor, to try to make sure that the DA's office understands, look, these are complete inconsistent statements, which raise doubt. Our job at the end of the day is to figure out how much doubt can we raise, but that's going to be based off of what exactly are the totality of the circumstances and the extent of evidence that they may have. This is what the discovery phase looks like. Every step of the way that we, at least here at the office, what we do is that we want to make sure that we contact our client, let them know, hey, look, we just collected this piece of evidence. We just gathered up this audio recording, this video recording. Why don't you come on down here to our office so that we can then make sure that we review that with you as well. And you yourself get the opportunity to understand this is what they have. This is what they ultimately can use against you in a court of law. And this way, every step of the way, we can be making diligent and informed decisions. This is your third phase. Now, moving on to the fourth phase. This is what I call the negotiation phase, okay? I don't want you to think that just because you heard negotiation, that we're immediately going to try to negotiate your case. That's not the case at all. I like to obtain certain options for our clients. This way, you at least have a set of options that you can look at and determine which is going to be the best one for you. What we do in this phase is that we gather up as much mitigating factors that we can then utilize to demonstrate to the state this is who our client is as a whole. Because right now, I need you to understand, they're looking at the offense report, they're looking at the officer's observations on this matter, they're looking at what the allegation consists of, and the person who got arrested does not get painted in a favorable light. And so our job is to figure out how can we make sure that our client gets presented in this, favorable light so that they understand this is who Mr. Santos is, for example. He's a hardworking individual. He's a family individual. He's trusted. He's, respected across the community. He's a helping hand here and there. These are things that we want to make sure that we highlight so that they then understand this is who you are. This is what's then going to allow us to hopefully have a higher likelihood of seeing if we can get a favorable option for you that you can then consider before you have to make your ultimate decision as to this is what I want to do with my case. Which takes us then to the last and final phase of the case, which is what I call the resolution phase. In this phase, after you have now considered your options, you then let us know this is going to be the one that I prefer based off of my particular circumstances, where I am in life, my future, whatever it is that you're considering to make that decision, this is what I want to do. And if that's, I want to go to a jury trial where we get an opportunity to go ahead and have voir dire, which is a jury selection process. And then the jury ultimately, a set of either 6 members if it's a misdemeanor, or 12 members if it's going to be a felony offense, they consider the evidence. And they consider the totality of the circumstances. They hear the arguments from the state prosecutors. They hear the arguments from the defense lawyers. But they also listen into witnesses and that they get put on the stand, and they determine how much weight am I going to give to this certain witness? How much weight am I going to give to this piece of evidence? There needs to be a unanimous decision that will then be made to determine, Mr. Santos, you are guilty, or Mr. Santos, you are not guilty. That's your verdict, right? That's the process of going through a jury trial. But before you make that decision, we want to make sure that you understand these are at least 2-3 different options that you have before you make that ultimate decision. And that's your resolution phase. This is ultimately, these 5 phases that I just went through here are how we handle here our cases at the office, so that we can then make sure that every single step of the way, you understand exactly what's going on, what is happening with your case, and you can make, once again, educated and informed decisions. If you're in need of any legal assistance whatsoever regarding a criminal allegation, call our office. More than happy to discuss the matter here with you in detail and figure out how it is that we can help you out.